Hello friends. Welcome to the new episode of You and the Law. I am your regular host, Gentle Queen. Please subscribe to my channel. In today's episode, we will look at the defense of intoxication under the criminal and penal codes. The Supreme Court in Imo versus the state stated that intoxication is simply a condition of being stupefied by alcohol or narcotics. When it is caused by alcohol, it is another term for drunkenness. At common law, drunkenness is manifested in any of these ways. 1. It may impair a man's power of perception, so that he may not be able to foresee or measure the consequences of his actions, as he would if he were sober. 2. It may impair a man's power to judge between right and wrong, so that he may do a thing when he is drunk, which he would not dream of doing when he is sober. 3. It may impair a man's power of self-control, so that he may more readily give way to provocation than if he were sober. While Section 29 of the Criminal Code governs intoxication as a defense to criminal liability in southern Nigeria, Sections 55 and 44 of the Penal Code govern intoxication in northern Nigeria. Section 29 reads as follows: 1. Save as provided in this section, intoxication shall not constitute a defense to any criminal charge. 2. Intoxication shall be a defense to any criminal charge, if by reason thereof, the person charged at the time of the act, or omission complained of, did not know that such act or omission was wrong, or did not know what he was doing. And a. The state of intoxication was caused without his consent, by the malicious or negligent act of another person. Or b. The person charged was by reason of intoxication insane temporarily, or otherwise, at the time of such act or omission. From these wordings, it is obvious that generally, intoxication is not a defense to criminal liability. However, intoxication may be a defense where the intoxication was caused by the malicious or negligent act of another person. Intoxication under Section 29 of the Criminal Code may be classified into voluntary and involuntary intoxication. Intoxication is involuntary, where the state of intoxication was caused without the accused's consent, by the malicious or negligent act of another person. So much so that the accused did not know that such act or omission was wrong, or he did not know what he was doing. Involuntary intoxication may also arise, where the accused took drugs, which has been medically prescribed, so long as he took them in accordance with the prescription. In any of these cases, intoxication shall be a defense, and if proven and established, the accused will be discharged. On the other hand, voluntary intoxication is not a defense to criminal liability. However, the effect of Section 29, 2b of the Criminal Code is that voluntary or self-induced intoxication by alcohol or other drugs can only be a defense to criminal charge if the intoxication produces a distinct disease of the mind, so that the accused is insane, within the Emnatan rule. The defense must prove that at the material time, the accused was suffering from a defect of reason, due to the disease of the mind, caused by intoxication, such that he did not know the nature and quality of his act, or that it was wrong. Therefore, Section 29, 2b, does not provide any defense, unless it is covered by Section 28 of the Criminal Code. That is, the defense of insanity. You remember we have discussed the defense of insanity.
So, voluntary intoxication under Section 29, 2b of the Criminal Code is only a defense if the intoxication leads to temporary insanity?
That is correct. In fact, in Imo versus the state, the court stated that the accused has to establish that his insanity was the direct consequence of intoxication, caused without his knowledge or consent, and that he was intoxicated by reason of the alcoholic drink he took immediately before or at the time of the incident. Lord Birkenhead, in DPP versus Beard, 1920 AC 479, stated that insanity, whether produced by drunkenness or otherwise, is a defense to the crime charged. An important observation in respect of this exception is that the distinction between temporary insanity, caused by intoxication, and simple drunkenness, is not easy to make. This is unfortunate since the distinction is important, where the accused alleges that because of the excessive drunkenness, He did not know that his conduct was wrong. Now, both the defense of insanity and intoxication have a common bond. This is that in either case, the accused must establish that at the relevant time, he was deprived of the capacity to understand what he was doing, or to control his actions, or to know that he ought not to do the act, or make the omission. Where it is established that the accused was insane temporarily, he would be acquitted. However, he would be treated as if he were insane and kept in a hospital, pending the pleasure of the governor. Where it is established that the accused had not formed any specific intention before the commission of the act, the defense of intoxication will avail him. This is as provided in Section 29(4) of the Criminal Code. The subsection reads as follows: Intoxication shall be taken into account for the purpose of determining whether the person charged had formed any intention, specific or otherwise, in the absence of which he would not be guilty of the offense. However, where the law imposes objective liability, then the accused will suffer by reason of his drunkenness. In offenses of strict liability, proof of mens rea is usually dispensed with. If an accused person commits an offense of strict liability under intoxication, the defense of intoxication will not avail him. In addition, there is also the problem of Dutch courage. If a person who decides to commit a particular offense of specific intent takes alcohol or drugs to give himself the courage to do so, he cannot rely on his intoxication at the time he committed the offense to establish that he did not have the requisite mens rea. The leading case is AG Northern Ireland versus Gallagher, where Lord Denning stated, and I quote, "If a man while sane and sober forms an intention to kill, and makes preparation for it, knowing it is wrong thing to do, and then gets himself drunk, so as to give himself Dutch courage to do the killing, and while drunk, carries out his intention, he cannot rely on his self-induced drunkenness as a defense to a charge of murder, nor even as reducing it to manslaughter. He cannot say he got himself into such a stupid state that he was incapable of an intent to kill, and the wickedness of his mind before he got drunk is enough to condemn him, coupled with the act which he intended to do, and did do." Now, let us look at intoxication under the Penal Code. Section 52 of the Penal Code provides as follows: Nothing is an offense which is done by a person who at the time of doing it is by reason of intoxication, caused by something administered to him, without his knowledge or against his will, incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Section 44 of the Penal Code provides as follows: A person who does an act in a state of intoxication is presumed to have same knowledge as he would have had if he had not been intoxicated. Where an accused while being voluntarily intoxicated commits an offense under the Penal Code, the consideration of whether he intends to commit the act is irrelevant. In fact, Section 44 of the Penal Code put the matter beyond doubt by stating that whether a person does an act in a state of intoxication or not, he is presumed to have knowledge of the act done. Intoxication can only be a defense under the Penal Code if the intoxication is caused by something administered to the accused without his knowledge. In Patrick O'Keefe versus the State, 1969, 1 All NLR 275, the court held that under the Penal Code, only involuntary intoxication can be a defense. Let us now look at the case of Kofi Mensah versus the Queen, 1952, 14 Waka 174, to find out how the defense of intoxication availed the accused person. Kofi Mensah was so in love with a woman named Akuagini that he desperately dreamt of marrying her. Both parties cohabited for some time, until Akua disappointed him, telling him she was done with the relationship. Out of his disappointment, he drank illicit gin. As what appeared to be their last act together, Kofi Mensah invited her to accompany him to the bush to gather mushrooms. She agreed in the presence of her mother. On their way, they both stopped by the lady's uncle's farm, who offered palm wine to Kofi. He drank, after which they continued their journey. When they got to the bush, Kofi stated that the wine started to affect him. He did not know what happened until he saw the lady lying in her pool of blood. He ran away from the scene, tried to kill himself, but subsequently surrendered to the police. Kofi shot the lady, but he swore he did not know how it happened. In his statement at the police station, he stated that it was not intended. It was the wine that made him do it. He was subsequently arraigned at the High Court for murder. He pleaded not guilty by reason of intoxication. After the trial, the court found him guilty of murder and sentenced him to death. Dissatisfied with the judgment, he appealed to the West African Court of Appeal. The issue before the court was whether the learned trial judge misdirected himself when he declined to consider a verdict of manslaughter. After a considered trial, on the 11th of September, 1952, the court delivered its judgment.
The deceased was a married woman living apart from her husband. The appellant's case was that, believing that she had finished with her husband and was willing to marry him, he had cohabited with her and was anxious to marry her. Shortly before the material date, he was disappointed in his hopes, and in that disappointment, took a certain amount of illicit gin on the day in question, and later that day, invited a woman to go with him to a farm to pick some mushrooms. There was no evidence to rebut that evidence. There was some to corroborate the fact, namely, that in the presence of her mother, he had invited the deceased to help him collect those mushrooms. They left the village and on their way, stopped a while at her uncle's farm where he partook of some palm wine. He was carrying a gun which, he says, he gave the deceased at some point, and took it back when they got to where they were to collect mushroom. At this stage, he says the drink began to affect him, and that from that moment, and until the moment when he found himself lying beside her, and covered in blood, he had no recollection whatsoever of the events which intervened. After an abortive attempt at suicide, he surrendered himself. The learned judge held that the appellant deliberately and intentionally shot the deceased, that he took her to the bush for that purpose, that he gave way to a desire for revenge, and that in consequence, a defense of drunkenness could not be considered. If there had been evidence upon which to found his finding of a preconceived intent to kill, we would not quarrel with that conclusion of law, but in our opinion, no such intent could be inferred from the conduct of the appellant, that is, apart from a possibility of a motive of revenge, as a result of frustration prior to leaving the village to look for the mushrooms. Indeed, the whole conduct of the accused negative such preconceived intent. It is impossible to say that if the learned judge had properly directed himself, he might not have returned a verdict of manslaughter, on the ground that intoxication had negatived any intention to kill. There was evidence of intoxication, which remained unrebutted, and should have been considered by the learned judge. His failure to consider it amounted to serious misdirection. For these reasons, we quash the conviction for murder and substitute one of manslaughter, and substitute for the sentence passed at the trial, one of 10 years imprisonment with hard labor.
Welcome back. I believe the Mensah's case well demonstrates the defense of intoxication. Let me know what you think in the comments section. And please continue to desist from all forms of crime. Bye. See you soon.